All right, folks, it's time for our favorite, yes, our favorite podcast, Cut to the Chase. I brought on Amanda Bronstad to talk all things mass torts. How are you doing today, Amanda?
I'm doing great. Thank you.
All right, Amanda is a journalist, and she also actually, conducts interviews on her well, it's not her podcast, but she does what? Legal Speak. So law.com, major big publication. Some of us see ALM. It's almost the same thing. And then the Daily Business Review. So she writes on things about mass torts, class actions, and she has a newsletter, which I have not subscribed to, but I will. I made a note, Critical Mass, which also covers all these kind of topics. So why did I bring Amanda on today? Not, listen, I've been reading your stuff for a couple of years. I've been sort of newish into the mass tort space. There's so many campaigns going on to try to figure out what's going on in all these campaigns. It's almost impossible. So I said to myself, well, hey, I'm going to bring Amanda on. I bet you she knows everything and she could give everybody, listen, there's lawyers that don't know what's going on. They have cases, they see oh my God, there's a $75 million verdict in 3M. Is that my case? I've got clients all over the place that, tell me that they have law firms that are handling the Roundup case. They can't get calls back. They don't know what's going on. So this is what this show is about. We're going to talk about 4 or 5 different of the bigger mass torts. And Amanda, you are going to give us updates. You ready to roll?
I'm ready.
All right. I think we should start with Roundup, which to me was sort of like, the thing that got me really revved up about the whole thing. Roundup, what's going on with Roundup? How many trials? Are there anything going on right now? I know there's news in the newspaper about the administration not, saying yes or, on the first verdict that they supported. So let's talk about Roundup. You talk about it.
Okay, great. Well, this is a really interesting mass tort because one of the unique factors about it is that Roundup is still on store shelves. So it's not one of these things where Monsanto, which is now Bayer, can just resolve all the litigation and move on. It's got to worry about future lawsuits because if you continue to sell the product, people may continue to file lawsuits over cancer that they claim that they got from using your product. So one of the key problems for Bayer is that they really don't want to put a label on the product to say that it causes cancer. And this is really the underlying fight. It's kind of, in the legal terms, it's really federal preemption that is the issue in a lot of these cases now. They tried to settle these cases in 2020. They agreed to pay almost $10 billion, but they couldn't resolve the future cases. And I believe there are still several tens of thousands of cases that were not part of those settlements. So there's still a lot of cases out there. Not many of them are going to trial. What Bayer's really trying to do is resolve this by going to the United States Supreme Court. And that's what's been in the news recently. And that is a case, it was actually the second bellwether trial that ended with a $80 million verdict. It got lowered. And it was upheld by the Ninth Circuit. And so Bayer brought this to the Supreme Court. And one of the things that happened just recently this month is the Solicitor General filed an amicus brief. And that amicus brief did not side with Bayer, which is interesting because 2 years ago, the same case was in front of the Ninth Circuit and the Justice Department sided with Bayer. And when I say sided, I mean the federal preemption argument. And the main argument here is that Bayer is saying, you can't have us put a cancer label on our product because it violates federal law. The EPA has stood by the key ingredient in Roundup, which is glyphosate. I'm going to say that at least a couple of times wrong.
Okay.
So basically, that's what the main issue is for Bayer, and they continue to argue that federal preemption is on their side. In particular, it's the Federal Insecticide, Fungicide, and Rodenticide Act. And they're just basically saying, look, if the EPA under that act says that this product is safe, you can't have us have a conflicting label on our product. So the fact that that now the Biden administration has switched sides on where the federal government stands, and this is a really big issue. And obviously, there was a letter that was filed by a bunch of agricultural groups this week that were basically saying you need to withdraw this, it violates federal law. The whole point of this is that if Bear loses in front of the Supreme Court or doesn't even get the Supreme Court to hear its case, it's going to have to start a claims process, probably under Ken Feinberg. But it'll have to start paying claims in continuum, and we don't know what that means specifically. So that's kind of what's at stake, and it's a big problem in the Roundup litigation. So as far as any future trials, I'm not aware of any. That doesn't mean they aren't going to happen at some point, because there's still cases out there.
Okay, so Ken Feinberg, he is the go-to mediator that a lot of the federal judges will use in big mass tort cases. And he wrote the book, What's the Value of a Human Life? I think that was the name of the book.
Yes, correct. He does a lot of the mass tort settlements. He did BP, he did GM's ignition switch claims process. I mean, he's the guy.
He's a busy guy. And when you talk about claims, all right, so if the Supreme Court doesn't take the petition, that doesn't, agree to hear the case, or they do and they say the case stands as it is, when you're talking about claims, you're talking about future claims, people that get non-Hodgkin's lymphoma, after being exposed to Roundup glyphosate, they would essentially, that's their lawsuit. They file a new lawsuit and it would get processed through Ken's mediation process.
Presumably. I mean, back in 2020, when Bayer announced the settlements that it said it was going to do in the Roundup litigation, it announced something called actually, this was last year. Last year, they announced a 5-point plan, they called it. One of those plans is potentially a claims process. Another part of the plan is this Supreme Court case. So this is all they've got a lot of options. And they're looking at a lot of options. But all of this came about because Judge Vince Chabria, who's overseeing the multi-district litigation, rejected their class action settlement that they tried to reach. It was kind of this novel, new type of class action settlement that would resolve future Roundup claims. And it was $2 billion, and Vince Chabria didn't like the plan, so he rejected it twice. So that kind of left them with now what do we do? So this is all part of their 5-point plan. Another interesting option for them is to come up with a different label of their own that they feel would comply with federal law. So it'd be interesting to see which avenue they take. And I think a lot of it's sort of all on the table right now.
Now, I thought that they were going to take the product off the shelf for, non-commercial users, just for your ordinary person that wanted to, get rid of the weeds in their yard.
Well, there may be some limited decisions about withdrawing, taking some of the product off the shelf, but that's really not their game plan. They're really not going to do that. So I don't really see that as being a major, there may be some parts of it in the United States that they may need to do. They sell a lot of this product throughout the world. So, so it would be interesting to see, though, which avenue they take going forward. I don't know if that's one of their really big ones that they're looking at right now.
Well, as the summer season is approaching, I did see their ad on TV, and I just couldn't believe it after all of this. They settle for whatever they've settled for, and they're still just pumping it out. And it's not like Bayer is a one-trick pony. They've got other products out there. But the ad was, I have to say, I know what's going on with the cancer and all that, but the ad was so persuasive. It was just such hey, it's the summer season, get rid of your weeds, with the Roundup or whatever. And it's just unbelievable. But all right, just to make sure the people that have actually settled the Roundup cases don't have to worry about all this future, like there's a case in the Supreme Court. They don't have to worry about that. Their settlement is done and that's it.
Yes, and a lot of the settlements, it's interesting because when I started this beat eons ago, a lot of the mass tort settlements happened on a global scale. So you saw this massive settlement of numbers of cases throughout, like say a whole MDL or something. In this case, you didn't see that. You saw a lot of the cases settling based on who their lawyer was, the inventory of cases that lawyer had, and negotiations that lawyer had with Bayer specifically. So they kind of are trickling through each of these settlements, but a lot of them have resolved at this point that were initially negotiating last year.
Yeah. So in the old days, when there would be global settlements of a mass tort, it would be across the board. All the law firms, all the cases would get settled. And now the new trend, with the Bayers of the world is, let's go to this law firm. We're going to give them one deal. You go to another law firm, you're getting a different deal. And then some law firms are like held out, and, and they're not even settling. And so I know that, I'm involved with a couple of different law firms, and I could see that it's not apples to apples. And what I heard in the 3M case, which we'll talk about shortly, is that the judge there is not going to put up with that at all. From what I'm hearing, the judge is going to force, there's a settlement, it's across the board. Not that I know that there's going to be a settlement, but she's already mentioned that from what I've been told. All right, now let's move on to my second favorite topic, which is bankruptcy. How are these Fortune 500, and listen, I have shtick, I get aggravated, and I'm like, how are these Fortune 500 companies filing for bankruptcy and getting off of pennies on the dollar? I mean, let's talk about the opiate litigation. Where are we with that? That's like the first one that I saw, that they were using this bankruptcy Texas two-step procedure to I guess close out these cases.
Okay, well, just to clarify, there have been some opioid companies that have filed for bankruptcy. The Boy Scouts filed for bankruptcy. These are all mass torts that got resolved through the bankruptcy system. But the Texas two-step was specific to a bankruptcy involving talcum powder. Yeah. And in particular, that was Johnson & Johnson that went through what's called a Texas two-step process. It's a merger process before it filed for bankruptcy. And it created a company specifically designed to file for bankruptcy. So the whole point of the company was to file a Chapter 11. That company is called LTL Management. Unlike the Boy Scouts and the opioid litigation that filed for bankruptcy, what's so big about this, and what I hear a lot from the plaintiff side, is that this is a company, first of all, that didn't exist until Johnson & Johnson went through this two-step process. But also, there's a big question about whether there's financial distress here. So like in Chapter 11, you have to have financial distress. I think it's kind of clear that companies like the Boy Scouts and some of these opioid companies, I mean, they were hit with so many lawsuits, their pocketbooks definitely reflected some financial distress, yeah, to say the least. So in this case, though, you have Johnson & Johnson kind of in the background, right? And everybody sees that that company certainly isn't in financial distress. And the argument is, wait a minute, why are we filing for bankruptcy? Why is this going into the bankruptcy system when Johnson & Johnson can pay for these verdicts and settlements, whatever happens in the talcum powder case? So that's a big distinction, and that is why there was a big effort to dismiss this Chapter 11 case early on. The filing was in October 14th, and they had already filed motions to dismiss before the end of last year. So that hearing was in February 25th. And the judge in that case is a very well-respected judge, Chief Bankruptcy Judge Michael Kaplan in New Jersey. He declined to dismiss the case, which was a big setback for the plaintiffs. But I also heard from a lot of folks that it was probably expected, because it's a very high bar to try to dismiss a Chapter 11. Yeah. So Judge Kaplan basically had a number of reasons why he did not dismiss the case. First, he found there was no bad faith, which was that's kind of what you have to prove in New Jersey in order to dismiss a Chapter 11. The other thing is that he actually found there was financial distress because there was a $4.7 billion verdict against Johnson & Johnson in a talcum powder case involving 22 women. So that's a lot of money, right? Also, he had an interesting take on the potential alternatives to bankruptcy. And this is where I think you can learn a lot from why we're seeing so many of these bankruptcies and mass torts. What he's saying is, okay, you could go through the MDL system and have those global settlements like you used to have. But one of the problems with that is you have a lot of state court cases that are not part of that. Even in the Roundup, which we were just talking about, there's 100 cases in Pennsylvania state court right now involving Roundup. They're not ever going to be part of those MDL settlements. The other thing that he mentioned was that, I guess they use the term the lottery system of trials. Okay, so in talcum powder, we have 38,000 lawsuits, and a couple dozen have gone to trial and gotten verdicts, but that's a pretty small number, by comparison. And there's every chance your case never goes to trial. And I think that's what the judge was looking at was, how can we benefit everybody? We're not trying to benefit like the lawyers. We're not trying to benefit this particular person. We're not trying to benefit the company. What we're trying to do is benefit everybody.
Yeah.
And I think that's what he basically walked away saying. The next step for all of this, of course, is then to come up with a reorganization plan. And Johnson & Johnson's willing to pay $2 billion. I don't think the plaintiff's lawyers are even close to happy with that.
All right, so there was previously a settlement with Johnson & Johnson on a lot of the talcum powder and cases, and it was my understanding that the expectations at that time was that they were going to do all the cases, but that didn't happen. Did I get that right? Because that happened a little bit before I started to get a little deeper into the mass tort world.
A settlement with the talcum powder cases, I haven't heard a whole lot of talk about settlement. I think that was also probably one of the reasons. In fact, there were actually 4 trials that happened right before they filed for Chapter 11.
Yeah.
And Johnson & Johnson won those trials.
Yeah.
They were actually winning in court. And there's all this speculation that maybe the juries had changed coming back from COVID and, looked at science differently. I did a lot of stories about that because people were talking about how strange when you had all these plaintiffs' victories before. I think the prospect for Johnson & Johnson was billions of dollars more in defending itself in court. And that was something they cited when they filed this LTL management bankruptcy. So I think that the parties are very far apart on settlement numbers.
Yeah, but I thought there was a partial settlement earlier on some of the talc cases.
There may have been, yes. There may have been a portion that they did settle. Again, I think a lot of this is, you see a lot more lawyer inventory settlements. So if there's a certain lawyer that does want to settle his cases, he's going to be free to talk to Johnson & Johnson. What's interesting about the talc litigation is you do have an MDL in New Jersey, but the vast majority of the cases are in state court. So the vast majority are being handled outside of that MDL and outside of the lawyers that are leading that MDL. So they can have their own negotiations as well. So, that's always open and that's always a possibility. But there's still 38,000 cases that are stayed right now because of the bankruptcy.
All right. So does the bankruptcy subsume the state court litigation also? Or is that separate from the bankruptcy proceeding?
Oh, no, it stops everything.
Yeah. Okay. Gotcha. All right. Yeah. So, my experience, a motion to dismiss, they're always denied because it's a high bar, like you said, and you have to wait till the end of the case before an appeal takes place. I know that there are opportunities to take an appeal after a motion to dismiss. Has that happened here?
Yes, they have already appealed. They're very quick to do that.
And where did that go?
That's a very good question. I have a feeling that's probably in front of the district court right now, but they may have appealed directly to the Federal Court of Appeals on that one. They have an option. They can do either one.
Yeah.
I would have to go back and look. At that. I don't know which one they filed in, but
as far as there's no real news on the appellate front. It's not like the case has been briefed and the judge is just going to.
No, they're definitely just starting that process. But that was something they moved for very quickly.
All right, now let's shift over to the Boy Scouts. Boy Scouts Association also filed for bankruptcy, Chapter 11, which means reorganizing. It doesn't mean getting rid of all their debts altogether, thrown in the whole towel. This was a reorganization. Where are we at with that? That's not this, like you said, it's not the same kind of Texas two-step that Johnson & Johnson has gone through. This is a little different. So explain how it's different and what's the status on that.
Okay, well, in that case, they're much farther along. So they're in a confirmation process. There was a hearing March 14th to April 14th to try to approve the confirmation of the plan, and 85% of the creditors did approve that. And so I actually have a colleague, Ellen Bardash, who covers this case. So if you want to follow law.com and try to cover, learn more about that case, she's definitely the one that's doing that. She's out in Delaware. She says the word on the street right now is that the ruling should be coming down any day now. She's probably going to rule from the bench. And if approved, then you have a claims process that involves $2.7 billion in claims. In that case, I think the Boy Scouts definitely did have some financial problems because the overwhelming number of lawsuits against them. Yeah,
but they did have a lot of insurance, and I know a lot of the insurance companies have ponied up money to get these claims resolved.
Yes.
That's pretty standard. What about Boy Scouts that were sexually abused? That I know there's also, well, let's segue a little bit. Now, I'm seeing that I believe New York just passed some legislation opening the door on the statute of limitations. So somebody that, was in the Boy Scouts 40 years ago and never said anything or whatever, but got, sexually abused and, is now like, wow, I see they might be settling. Is it too late for me? What do you know about that?
That I don't know anything specific about, but I would guess just based on my knowledge of these claims procedures that it would probably end up in the claims process. I mean, one of the things the bankruptcy is designed to do is kind of put a cap on all of this. And so even if the Boy Scouts are continuing to operate, these claims are all going to be folded into whatever claims process comes out of this, if the plan gets approved, of course.
Yeah. All right. So 85% of the Boy Scouts were basically, they were all asked, do they approve of the settlement proposal? 85% of them said yes. And then the judge had a hearing on this whole matter and now is going to rule whether that settlement is approved.
Right. Exactly.
And then you have the whole claims process where Boy Scouts, your lawyer, the lawyers for the Boy Scouts submit their claims. There's a little, it's like making an insurance claim. You got to say your name and whatever information, and then you get plugged in. There's a number that you're going to get, and that's basically the ball game.
Right. Exactly. You got it.
Okay. Now, my girlfriend asked me, what about the Girl Scouts? Why is this only the boy? Like, are you telling me that the Girl Scouts did not? I mean, I have not heard anything about it, except that's my girlfriend's question. What about the Girl Scouts?
Well, I actually asked that question to my colleague Ellen about that, and she said the Girl Scouts is a totally different organization, first of all.
Okay.
So they don't even have any, other than having a very familiar name, they don't actually have any affiliation whatsoever with the Boy Scouts. That said, she did mention that they have a trademark infringement case against the Boy Scouts, and so they're part of this Boy Scouts bankruptcy only in the sense that they are actually opposing the plan because they want more for their trademark case that they have against the Boy Scouts. That, of course, got folded into the bankruptcy once the Boy Scouts filed.
Gotcha. All right. So now let's move on to my favorite case, the Sacklers and the opiate litigation. Before we get into the bankruptcy, let's just give like a little bit of a roadmap. Who's suing? What's going? I mean, because it's not just Purdue. There's a lot of players at stake. Walgreens and the manufacturers, there are multiple manufacturers, there's multiple retailers. Lay out who's getting sued and what the basic status is on all those. And then we'll end up talking about the Purdue bankruptcy and the Sacklers. That we'll leave that to the end.
Okay, well, basically everyone is suing everyone. Yeah. That's what it basically comes down to. A lot of the cases that I'm writing about are actually not the Sacklers, because once they filed for bankruptcy, it became part of and Purdue, it became part of the bankruptcy process. So there's a whole lot of other lawsuits still going on out there, and I've been covering a lot of that. The biggest development is last year there was a $26 billion settlement that involved the three largest distributors. This is McKesson, AmerisourceBergen, and Cardinal Health. It also involved Johnson & Johnson, whose Janssen Pharmaceuticals company was a manufacturer of opioids. So those four companies agreed to settle every case in the country as long as every case in the country wanted to settle with them. So what happened was you have an entire year where there's negotiations going on. One of the really unique things about the opioid litigation is that you don't have just states suing companies over the opioid crisis. Back in the tobacco days, those were all states that sued Philip Morris and all those companies. Now you have cities, counties, school districts, unions, health insurance plans. You've got everybody on board.
And
a lot of those.
And the tribes. And the Indians.
Yes.
And the Native American tribes, yes.
Yes, and so they are all filing their own lawsuits. A lot of them have hired their own lawyers. So one of the big sticking points here is that the question is, do you pursue your own case against these companies or do you agree to the settlement? And one of the big conversations there is, how much are they willing to get for attorney fees? Is the settlement going to compensate those lawyers enough for the amount of effort they just did? These cases have been going on for years. This is not just filed cases. And so those negotiations have been going on over the last year on whether to participate in the $26 billion settlement. And I think it was back in February that the defendants agreed to move forward with this settlement. The first checks supposedly they come out this month. And the reason they agreed is because 90% of local governments in like 40 plus states had agreed to participate in the settlement.
All right.
Those that didn't then would then go to trial on their own and just, hope they get more than what their share would have been if they had participated in the settlement.
All right, so we're going to separate this into two buckets. The government suing the retailers, the distributors, the manufacturers, and they're suing for the cost that they've spent to deal with the opiate crisis, either treating or just however it is that they've suffered costs. Did I get that right?
Yes, we're talking about things like the costs of treatment centers, the costs of police that have to go out and find people that are overdosed on the streets. All of those costs get piled up and end up being the cost to the city or the county or whatever entity it is, school district. So they are suing to recoup that. Yes, and almost all of these lawsuits are governments that are suing. We're not seeing, this is not necessarily addicts who are suing for getting addicted.
Okay, and we'll talk about that in a second. All right, but the governments and the tribes, if they settle and they get this money, I know that in the earlier part of the last year, the discussion was, so they're going to get this money and what are they going to do with it? They're going to plug potholes in, or are they going to use it for treating the current problem, which is obviously not going away anytime soon.
Well, I mean, that's the concern, right? So one of the reasons that these local governments filed their own suits instead of letting the states do it is because they feel like the states bungled the tobacco settlements. They feel like that money that should have gone to them ended up going to things that weren't related to smoking or anti-smoking campaigns or whatever it was that was agreed to. So that, people are looking at this with a very fine-tooth comb, definitely looking to see where that money's going. I can tell you for sure that Judge Dan Polster, who oversees the multi-district litigation, where most of these cases are, is definitely asking questions, and he's a little more involved than what I've normally seen with judges. So he's definitely taking a look at what these settlements are saying and where that money is going to go.
All right, so there are still some governmental entities that have not joined in the settlement, and they're trying their cases.
Yes, and there are still a lot more defendants that are not bankrupt.
Yes.
So 3 of them are the are pharmacies that just lost a verdict in November in the first bellwether trial in the multi-district litigation. That's CVS, Walgreens, and Walmart. And they just finished last week. They just finished an abatement phase where Judge Polster oversaw arguments on both sides about how much in money these 3 companies need to pay. It was a jury trial, but the dollar figures are being worked out in a second phase. The dollar figures that are being asked for from the plaintiff's side, I know, exceed $2 billion. So it's a lot of money that's at stake right now.
And there were a few courts and verdicts that went against the plaintiffs in the last 6 months. I think Oklahoma and maybe two other states said no go because they did not believe that the legal theory, public nuisance, was a viable theory.
Yes, that happened in California and Oklahoma. In Oklahoma, they had a trial several years ago where there was a large verdict against Johnson & Johnson. They appealed. Oklahoma Supreme Court not only overturned the verdict, but said you can't use public nuisance in this manner. Public nuisance is a law that isn't specific to opioids or any public health. And so basically the Supreme Court, now it's just specific to Oklahoma, but it was kind of a big red flag if you're suing over public nuisance to go, oh, this may not hold up on appeal. Yeah. The second issue was a California bench trial. And in that case, the judge issued a decision that basically, that was a little bit different. He didn't throw out all of public nuisance. What he said in that case was the plaintiffs put up these big charts. This was all done virtually, by the way, because of COVID. So put up these big charts that said, look at how many more people are addicted to opioids. Look how many opioids came out into the market. And one of the things the judge had a problem with was you're not saying which of those opioids helped people versus caused them to get addicted.
Yeah.
You're not differentiating. You're just saying there's opioids out there. Well, there's actually a really good case to be made that opioids are prescribed for pain.
Yeah.
And that they actually are useful. They are approved by the FDA. They haven't been withdrawn. So I think that was a big problem in the plaintiff's case. And so what's interesting, I was just thinking about those decisions, because what's interesting is we're seeing a lot of settlements happening right after trials begin. So they're not waiting for the verdict. They're settling in the middle of trial.
Yeah.
And I wonder if some of that is not wanting to gamble.
Yeah. So the public nuisance theory is basically being utilized in all these cases. I mean, that is the main legal theory, that the marketing where they were basically saying, hey, it's safe, it's not addictive, was false marketing. And that essentially created a public nuisance, ergo all these, addicted people that are dying and overdosing and, causing all this chaos was in fact a public nuisance.
Yes, the marketing is specific to the manufacturers because they're the ones that have the brochures and the materials they give to doctors. The distributors, the argument is you were under federal law supposed to flag when tons of opioids get sent to a specific community. The pharmacies is you sent out too many prescriptions. You should have known that that wasn't right. Yeah. So I'm being very general, but that's basically a little bit different arguments based on which of the three chains in the supply system you're suing.
Okay. And that's very, I mean, I think that clears up a lot, in terms of, why would Walgreens be on the hook? Yeah. I mean, if you're running a Walgreens in a town of 200 people and you're issuing, 20,000 opiate prescriptions, something's wrong. That's the law requires that you basically monitor, the amount so that you're not, obviously, flooding your market with, a highly addictive product. And, it's obvious something's going on here. All right, so now let's shift over a little bit. All right, so also the Native Americans, I believe they settled theirs entirely.
Yes, well, with the distributors, they did. Yes.
Okay. All right, and is there any trials going on right now? Is there any major?
Yeah, there's a few.
Sure.
Yeah, so basically what's happening right now, we have a bench trial in San Francisco against four companies. They all represent different chains. One of them is Walgreens. You have two manufacturers and a distributor in that case. That's going on right now. There are some settlements, however, in trials that just began that have just come out. Earlier this month, there's a $683 million settlement that Walgreens reached with Florida. What's interesting about that settlement is it wasn't just the state they settled with. They settled with like 240 cities and counties in Florida. I think that's interesting because if you read the settlement agreement, it reads very much like that $26 billion distributor settlement. And so what I think that's trying to do is create a lot more finality. Walgreens tried to resolve not just the state of Florida's case, but everybody in Florida's case. I'm kind of interested whether that becomes sort of a benchmark for future settlements. So, it'd be really interesting to read those settlement agreements because it really does outline what looks to me to be possibly the way to do these going forward. There was also a settlement in the middle of trial involving the state of Washington, $518 million. There was a settlement with the state of West Virginia on Wednesday that involved $161 million. These were all cases in trial, and they settled before reaching a verdict. So yeah, it's been a lot of those happening. This is all this year. There will continue to be trials. I believe there are some slated in the multi-district litigation going forward. I don't have the exact dates right now. They're still working all this out. With COVID, things get really dicey to try to figure out trial dates because they may have a date, but it gets pushed back or gets changed completely.
The judge gets COVID.
Yeah. Yes. So I mean, I can give you dates. They'll probably change next week.
All right. Well, this is more of a general, like what's going on. All right. So the last two parts of this opiate puzzle. What about the victims? What about the people that got hooked on opiates? They came in, they had a little hangnail. The doctor said, hey, go ahead, take this opiate or whatever. I'm going to give you a 2-year prescription or whatever to deal with your hangnail. And then the next thing you know, you're overdosing and causing all this chaos. What about the victims? Did they go to court? Did they sue for their own individual damages? Did family members of people that died of an overdose sue? What's going on with that?
I think the whole idea is let's give the money to the cities and the counties to treat those people. But no, I have not seen in the opioid litigation, I have not seen individuals, not that many. There have been some, but they're really not the main focus of that litigation. However, I do know some of those victims were represented in the creditors committee in the Purdue bankruptcy.
Yeah.
So I do think that's where their voice will be heard, is in the bankruptcy system. And Purdue is not the only company that's filed for bankruptcy in the opioid litigation. So as we move forward with more trials, let's watch and see. Maybe there will be another bankruptcy potentially. There's not any specific company that people have mentioned to me, but I've watched these companies file for bankruptcy since the lawsuits began. So Mallinckrodt is one of them. They're going through the bankruptcy system as well. Obviously, Purdue's the big one. They have the most public attention on that one. In that case, the bankruptcy plan was reversed by a federal district judge, and the case is now before the Second Circuit. The last I checked, my colleague Jane Wester in New York has been following that case, and she said there's no ruling yet from the Second Circuit. But in that one, you have the trustee and you have Purdue arguing to keep their plan in place in front of the Second Circuit.
And the crux of that appeal is the fact that the Sacklers, who were the family behind Purdue, did not join the bankruptcy, although they are coming up with some money for the settlement, but they want protection from criminal or civil litigation afterwards. And
yes, I believe
that's the legal question, is whether that a non-consensual release is valid. And that's a big issue. And I know a lot of people, I had Ryan Hampton on, who was on the committee for the unsecured creditors. He was a victim. And, he discussed what the victims were getting. He was all pissed off about the consensual release, non-consensual release. And he said the victims were basically slotted for like payments ranging from $3,000 to $48,000. And he was just completely offended at that number. People died or whatever. And so, that was, I know you listened to that episode, but no, I'm kidding. But that,
actually, I did.
You did. And I read his book too. He's a good guy.
Interesting.
I hope it all works out, whether, listen, a lot of from my circle, I'm always like, God, how many more of these how many more times are there going to be these mass torts? Like, when did they ever learn? And, my mentors, let's call them mentors, always say, until any of the CEOs go to jail for this stuff, it's never going to end, because they know whatever, will pay out some money and we'll live another day. So I think that, there's a lot of momentum towards having somebody really pay the price and not just monetarily. Okay. I said my piece. I spoke my piece for that on that topic. Okay. All right. So now let's talk about the next Juul.
Yeah, here I actually was thinking about Juul when you were talking about this, because in this case, you have the first bellwether trial, and it does involve someone who claims to be addicted to electronic cigarettes. It's a Tennessee teenager. I think the person is 16. They don't use their name. It's BB initials. And this is a person who's going to trial on June 21st against both Juul and Philip Morris, which owns 35% of Juul. So those are the two defendants. The Juul litigation has been going on for quite some time. It's there's about 3,700 lawsuits. They're all in San Francisco in the multi-district litigation. This is in front of Judge William Orrick, and he'll be overseeing this trial, which is a jury trial. One of the issues I wrote about recently was the time and time again issue of whether or not unvaccinated jurors should sit on the trial.
Yeah.
This is an issue that's come up so many times that there's actually, if you ever go to Lexis and just punch in unvaccinated jurors, you're going to get a whole ton of rulings that come out. So you have a lot of judges coming both ways on this. There are arguments pro and against, and I think Judge Orrick basically said, lawyers, you work this out, because I don't think he wanted to be one of the ones making a ruling on this.
Yeah.
These do end up in front of appeals courts too and get overturned. So there is no precedent necessarily. It's all being worked out in the courts right now as to what the answer is to that. So we'll see what happens with that. It's a lengthier trial, and it's the first bellwether, like I said. They do have a couple more bellwethers scheduled in September and November. The September one is an individual as well, who's claiming to be addicted. The one in November is actually a school district. So again, just like the opioid cases, there's a lot of different plaintiffs in the Juul litigation. You have school districts, you have, I believe you have Native American tribes that are definitely part of that litigation as well. So those are trying to all kind of get in front of jurors to make their case. And there's more than 2 defendants.
Yeah.
There are a lot of other electronic cigarette manufacturers that are part of this MDL. They all got lumped together. But obviously Juul's the one everybody's watching.
So the basic theory with the Juul litigation is, hey, you created this product that you said was essentially designed to get a smoker off smoking regular cigarettes, but it really, it turned out this is even more addictive. Is that the general gist of this litigation?
I think that was part of it for the adults who smoked cigarettes, but the main point of a lot of the litigation is younger kids who've never smoked, and they got introduced to it through Juul's marketing. So in the case that's going to trial next month, the teenager, I read a little of the court documents, and the teenager is basically saying, oh, I saw the ads. They were like those, they're on separate stands in the convenience store. You walk by. Some of them had videos with people dancing. It's very hip hoppy. They had flavors, you know, they're like candy flavors that the kids love. And, you know, except creme brulee. I kept thinking that's not a very very kid-friendly flavor. But they did have a lot of these other flavors that looks like candy to kids.
Yeah.
And so a lot of it is you kind of made it sound like this is fun and hip and not dangerous.
Yeah.
And here you've got all these teenagers now hooked. So I think the marketing to children is a really big part of this case because that was a really big market share that they had smoking their cigarettes. So
you get the kids hooked, you got a client for life. And what's amazing to me is Philip Morris, you know, when you talk about tobacco, you know, the litigation with tobacco, whatever, they had to agree not to market to, you know, to minors. And so
yes,
they are like, they're, you know, just turning the same playbook. And it's just unbelievable that it continues.
it kind of reminds me of the Joe the Camel stuff. Do you remember back in the tobacco days? That was, you know, the Joe the Camel cartoon was kind of designed to really focus on kids because it's a cartoon, and that was what the argument was in the tobacco litigation. So yeah,
it's crazy.
A lot of similarity.
So any settlement talk that you're aware of? Has a mediator been appointed? Is Ken involved in this one?
That I'm not 100% sure on. It's still pretty early in the litigation, so I don't think so. I would be surprised though if it didn't reach at some point. You know, the point of these bellwethers is to try to figure out valuations so that you can reach a settlement. And so if you get a couple of bellwethers out there, it kind of educates both sides as to what are we dealing with here in terms of dollar figures and gets them closer to the table.
All right, so that's a segue to the next topic, which is 3M, which has actually gone through all of their bellwethers, and it has not produced the global settlement that the bellwethers are designed to produce, even though, I don't know, there was 16 plaintiffs that have won or something like that, and the amount of money that's been won is pretty high. So what's going on with that one that you know?
Yeah, that one, the last verdict was May 20th. That was $77.5 million. And that was the largest award given to a single plaintiff in all of the 16 trials. There were 16 juries, 16 trials. Some of the trials had more than one plaintiff. So there was a verdict back in January that was $110 million, but that was for 3 plaintiffs. So if you divide that up. So definitely a big plaintiff's win on that one. The total tally at the end was 10 juries awarding a total of about 300 million plus, and then 6 juries siding with 3M. So obviously the plaintiffs feel like they won this, but 3M has appealed a number of these verdicts in front of the 11th Circuit. And I did read the appeals recently. I put it in my newsletter, trying to get an idea of what their arguments were. Unfortunately, these were all trials that were in person, which was, I'm sure, great for all the lawyers, but it was really difficult for reporters in California trying to cover Florida trials. So trying to get an idea of what was happening in the trial was a little bit difficult. 3M is kind of making this case that there was a lot of evidence that wasn't part of the trial that would have helped them. So that will be definitely something in front of the 11th Circuit to see what happens in those. That could obviously change the game. There's not any settlement talk that I'm hearing a lot about. I know that the judge in this case, who is Judge Casey Rogers in the Northern District in Pensacola, she has already ordered the lawyers to work up 1,000 cases for trial. And the next step is everyone talking more trials.
All right, so my understanding is the bellwether process is over. She has 280,000 cases that have originated from many, many courts across the country. And now she is sending those cases back to the original courts. Is that part of the process after the bellwether?
Yes, that's what she will be doing. She hasn't, I don't think she's quite issued those orders yet, but that's the plan.
All right, so if you're in one of these cases and you've been like, wow, look at all these victories, when am I going to get my money or whatever? Well, guess what? Your case now might be, going back to Oregon or wherever you originally filed it. And you might be getting a call from your lawyer, like all of a sudden, you might have to start sitting for depositions and all that kind of fun stuff.
Yeah. I mean, one of the things 3M's trying to hang its hat on is that it was a combat earplug. You can actually use both sides of it.
Yeah.
Depending on whether you want to be able to hear the guy talking to you next to you, or if you really just want to block out all the noise of the weapons going off. And so this was a product that really was exclusively used by the military. So 3M is definitely making a case that they didn't do the design work here. This was all military approved.
Yeah.
Of course, Judge Rogers has not agreed with them. She threw out their immunity defense on summary judgment. But we'll see what the 11th Circuit has to say about that, because that's obviously 3M's argument on all this. The other thing 3M is doing is they're challenging what they call administrative claims. So I did look up. This is a unique case because the Judicial Panel on Multi-District Litigation says there are 290,000 cases currently in this MDL. That makes it the largest MDL in the country.
Yeah.
But Judge Rogers put a lot of these in an administrative docket, and they are claims that officially haven't been filed as lawsuits. 3M has been fighting for several years now, trying to argue that a lot of those claims are meritless. And so the question will then become, the judge has to look at those and decide whether they can file these cases. And so I think that'll be interesting to see how that works out. 3M, of course, is saying there's a whole lot of meritless cases, and the plaintiffs are saying they're completely overselling this argument. So we'll all find out when they start getting remanded, I guess.
Yeah. All right. So two more. We're going to go through quick. Zantac and mesh. Your choice. What do you want to talk about first?
Well, I kind of like the Zantac cases, but the mesh is, I just wanted to say real quick on that. The transvaginal mesh was the litigation that everybody was following for a long time. Those have all been, frankly, really resolved. And so it's mostly hernia mesh cases that are kind of going through the court system right now. There are some MDLs. There's one actually in front of the panel yesterday involving Covidian mesh. We'll see whether or not the panel approves that. Last time they rejected it as an MDL. So some of those are still out there. That's kind of the focus. And there have been a few trials of those for sure. In Zantac, again, this is a judge I've been watching closely. U.S. District Judge Robin Rosenberg in Florida's Southern District. Everything's happening in Florida.
Isn't that amazing? We got an air show going on right now. If you hear planes flying over my head, what's going on?
She has. The U.S. Judicial Panel on Multi-District Litigation says there are 2,000 lawsuits in this MDL, but I have heard the lawyers mention 140,000 claims. So it's a much bigger MDL than it looks on paper. Again, a lot of these are in the administrative docket that Judge Rosenberg set up. One of the things that I personally really think is interesting about this MDL is that the judge created a new idea called a Leadership Development Committee. And this was when she appointed the lead plaintiff's attorneys. This is back in 2020. And she created this committee for younger lawyers to get a little bit more involvement in the MDL. They got to argue the dismissal motions. This is on both sides, actually, because the committee's now expanded to include defense as well. So it's a very interesting strategy they're using to keep from having the same senior lawyers make the arguments over and over again and give younger lawyers a chance to be in front of the judge. Judge Joy Conti Flowers in Pennsylvania actually mimicked the same idea in the MDL over the Phillips CPAP recalls. So this is definitely something judges are watching just in terms of changing the players a bit
Yeah.
in plaintiff's bar and mass torts.
Yeah. The old guard, as they would say.
Right.
Yeah.
Right.
I don't know if I'm in the young or the old, but maybe I'm in neither. Let me just ask you one more question about the mesh, the hernia mesh. Sorry, you said the transvaginal are all resolved, they're all settled, or most of them?
Most of them are. I looked at the, most of them were in 6 dockets in West Virginia, and those have all been closed. So those cases are definitely completed. One of the things that's still out there with the transvaginal mesh is there was a state of California bench trial against Johnson & Johnson where they won $344 million of a verdict. And that one was just recently upheld by a state appeals court. They reduced it to about $300 million.
Yeah.
Boston Scientific also settled with a bunch of states last year. So those are kind of like, tying up the end of the litigation, I think, with a lot of the states. The ones that are still out there are hernia mesh. I know barred hernia mesh is a litigation where there was a defense verdict last year and a plaintiff's verdict last month for $250,000. And then there's another MDL for Johnson & Johnson's Ethicon PhysioMesh, which is about 3,600 lawsuits right now in that MDL.
So the hernia mesh, they're not even talking settlement, or it's early on? What's your understanding?
Well, it kind of depends which hernia mesh.
Yeah.
I think in the ones I just mentioned, those are fairly new still. It'll be interesting to see if the barred one starts to settle, because they have had a couple of bellwether trials, and let's see what happens. Covidian, of course, what's interesting is that one, they tried to get an MDL created, and that went from 12 cases, I think it was, to now 73 cases in federal court and 4,700 cases in Massachusetts state court. So that one's a growing MDL that I think they're trying, well, I should say a growing mass tort that they're trying to MDL.
Yeah. All right. I think that pretty much wraps it up. That's a lot of information. And I got to tell you, even if nobody listens to this podcast, I thank you tremendously for catching me up to speed. So I can, when my phone's saying, what's going on? And I'm like, oh, what are you? Oh my God.
It's hard to keep them all straight, but it's a fascinating area of law.
It really is. It really is. All right. Listen, I'm going to have to bring you back regularly now, to give us regular updates. Okay. And my next move is to subscribe to your newsletter. And I thank you for coming on. Nice to meet you. And have a good, happy Memorial Day weekend for you. All right.
Thank you.
You can
thank you. You too. For sure.
Right.
Thank you.
All right, everybody. That's it for this episode of Cut to the Chase. You know what to do. Subscribe, rate, and review. You go to Apple Podcasts. You find Cut to the Chase, : remember, : then you go down to the bottom and you click 5 and you say, this is the best show ever. And then I'm happy. Okay. And if you have any questions, if you want me to, bring her back and, you got all these questions, you want to talk other, the CPAP. I mean, believe me, there's lots of other, mass torts that are out there and that are going to be out there, unfortunately. Okay. Amanda, thank you. And we will conclude with a goodbye.
Bye-bye.
All right.